If you're creating low content books for Amazon like coloring books or puzzle books, you already know there are specific rules and regulations you have to abide by in order to be on Amazon. You also know that there's a legal side for copyright protection of this as well. Let's have a conversation with everybody's favorite IP and entertainment lawyer, Tony, to find out more about the legal side of creating those low content books.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
We're getting a lot of questions on the YouTube channel about low content books, things like puzzles or coloring pages. We're getting a lot of people asking, can I use AI generated puzzles or coloring book pages to create these low content books and put them on Amazon without having any issues? From a legal perspective, Tony, what do we need to know about this?
All right, so if you don't care about copyright protection, if you don't care that you're just making something AI generated, be my guest, that's fine. But obviously we have to look at this through the narrow lens of understanding, about copyright protection, about being authentic online in an online marketplace like Amazon KDP. So let's break it all down. Now with Amazon KDP, there is inclusion of information about whether or not the work that you created is AI generated. If you're not being truthful about that, if you are using a Midjourney, a Stability AI, DALL-E, whatever other platform to make AI generated images that would be used in a coloring book, and you do not properly disclose that that image was generated using artificial intelligence, that's a problem. That could be a termination of your account with KDP. That is something that is in direct breach of the terms and conditions that you agreed to. You didn't read, but it's that long list of terms and conditions that you just automatically hit accept when you signed up for an Amazon account. So understand that if you're not honest and truthful about something being AI generated, that could be a problem. But number two, we've talked about it in ad nauseum in previous videos, and I will say it till I have beheaded myself, that which would be kind of funny in time for Halloween.
Yes.
Bottom line is anything generated using artificial intelligence will not receive copyright protection. This is not an issue of ethics or things, well, ethics for sure, but not an issue of like it being illegal necessarily. Rather, this is a matter of whether or not you actually care about protecting the work that you invest time and effort into creating. And if you're the kind of person that has made coloring books or low effort type of product organically, and now AI came to the rescue as the knight in shining armor, you have to then have this moment of realization that AI is the kind of thing that I think personifies the expression, all that glitters is not gold. You know what also glitters? Oil. And it ain't that, unless it's like processed into something a bit more fine, it'll have value. But at the end of the day, oil is nothing compared to what gold presents as value. And that I think is a good analogy to what we're talking about with generative AI. Anything that we generate using artificial intelligence will not receive copyright protection, period. This is coming from the US Copyright Office. They have made this policy very clear. Why? Because they say that anything generated using artificial intelligence lacks substantial human involvement. There is plenty of case law that has talked about how copyright, the fibers of copyright rely heavily on the human author, that the human author is the entity that makes an original work of authorship. This has been supported even in case law like the Naruto v. Slater case, where while a monkey touches the shutter of his camera and takes a picture of himself, while he made the copyrighted work, he cannot appreciate or understand the rights that come with being a copyright owner. Thus, he can himself be the copyright owner of his own photograph. This is something that copyright law has touched on heavily over the course of history. So human authorship is something that I think is indisputable and something that has been heavily addressed at the judicial level. And that's why the Copyright Office has taken that firm stance that, in the same vein, generative AI lacks that human authorship requirement, because at the end of the day, asking the AI to make something isn't the same as you actually making it. That's the difference. Now, obviously, there are going to be people that will go after me in the comments, and I'll take it like a champ, where they'll say, well, the input is the information. That is the work. Is it really? I think it's a matter of opinion at this point, but I think over time, we're going to need some more clarity of what requires substantial human involvement. That actually, I think, is the next phase of questions that is going to come down in case law, which then segues into the other aspect of things here with AI, which is that case law has affirmatively stated over and over about the substantial human involvement prong, but we never had it from the generative AI point of view. Well, we have the Thaler versus Perlmutter case that just went down in the DC District Court, the very first AI case related to copyright law that just came down a few months ago, that affirmatively states that generative AI cannot receive copyright protection because it lacks human authorship. Obviously, that case will be appealed. I have a feeling that it's going to go all the way to the Supreme Court. It's too good to not go there. Either way, I think that is really where all that information should be the kind of thing that a content creator on KDP should sincerely consider when they are making any sort of generative AI works and publishing on the platform. Yes, it's low effort. It's the kind of thing where it's meaningless. You throw it up, it's not a big deal, right? But if you really do value the protection of the work that you put into making copyrighted works, then I think you should really reconsider using generative AI when you are when you have all this case law and all these rules coming out from the Copyright Office, from the DC District Court. These are things that you just cannot ignore at this point in time. The only way we will have better understanding or even better protections for generative AI and copyright is if those types of laws pass, or if case law create certain boundaries or applications of copyright law to the generative AI space. But right now, it is the wild, wild west. We don't have the voluminous level of laws that a lot of other aspects of IP have. So for now, acknowledge the fact that generative AI cannot get copyright protection. And don't forget that if you don't disclose that you're making something with generative AI on KDP, that could lead to a termination of your account. So I think the two words that I would leave you with are think wisely.
That's a very valuable advice. Now, I do want to point out that not every program that you are using to create some of these low content things for your books is AI. And we've gotten a lot of questions and conversation on the channel about that. So, Tony, if we are working with a program that is not AI, which you learn by going to the terms of service on the website, you're doing your research with the programs you're using and the terms of service that you are agreeing to. So, you know this before you use it. If you haven't, go and do it now. If we are just using a normal program that is not AI, does that change the legal stance of things?
It doesn't at all, actually. If you're using a photo, let's say you're using Photoshop, Photoshop is no different than a canvas, right? If you were to actually draw on it, so it's kind of interesting because I've also heard that comment a lot by a lot of people, where people say, oh, well, DALL-E, Midjourney, all these, they're no different than Photoshop or some like other animator app. It's all computer code. But here's the thing. Like you said, obviously Photoshop or Final Cut or any of these other platforms that are out there that people could say are AI, those are just programs. But you have to remember that at the end of the day, there still is the requirement for you to make something on those platforms. You open it, but it's not going to do everything on its own. There still needs to be someone behind the screen actually doing something. So if I open up a 1000 by 1000 pixels page on Photoshop, Photoshop isn't going to, I can't press like the enter button on my keyboard and it's going to do all the work for me. No, I actually have to pick a brush, pick the lasso tool, pick different colors, pick different brush widths, whatever it is. There still is that requirement for me to make that work. I'm just expressing it I'm the one still doing the work, but I'm expressing it on a digital medium. I could do that exact same thing on a physical canvas. I could do it on a piece of paper with pencil, whatever it is. It's still the same. I'm still evoking the same message of my mind, using whatever ideas that are in here, expressing it in some fashion on a different platform. It is quite literally the antithesis of what generative AI is, which is you're asking the program to do the work for you. Okay, the operative words there, for you. You're not doing the work. The AI is doing the work for you. That's different. Now, we've talked about it before recently. There's the new generative AI filter feature that is on Photoshop, where if, let's say, you put a photo in and you want the the AI of Photoshop to fill out the rest of the image, that's a bit of a different story. That kind of thing also is leading to more of like a mixed bag of questions. Is the copyright going to extend to that little extra something? Is the work as a whole still being completed by a human author? Does it still have substantial human involvement, or does it lack it? Obviously, that's a lot of gray area questions, but that is different from the art of, or the act of picking brush and brushing on your own using your actual physical digits, your hand and your mouse, and touch, and having your way on that platform. So, I think that that's really important to emphasize. And just one last thing, these programs themselves are protected under copyright. This is that type of content, or that type of product is a type of copyright that itself is protected. So I think a lot of people over time have viewed those uh, products individually as a copyright, but then in addition, they're
Mhm.
also just tools that are used to help an author create something out of it. So you can be a filmmaker, use Final Cut Pro as a way to still evoke the message of what you, the creator, are trying to evoke with your short film or television show or movie, whatever it is. If you're an author, you can still use Photoshop to help express that message that you, as an artist, are trying to express by some digital means. And if you could do the exact same thing with a canvas, the canvas is your means. It's basically your blank slate to help express a message that you, the author, the creator, want to evoke in some sort of fashion.
So if you are creating low content books, coloring books, puzzles, things like that, there are a couple of things you need to remember. First and foremost, you do have to disclose any use of AI if you are putting this on KDP. You do have to understand the difference between programs that you can use to create things entirely on your own, programs that will generate things based on things that you're putting into it, and AI programs. You need to make sure you understand the terms of service and the permissions and rights you have granted by the programs you're using to create what you are putting into these low content books. And then you also need to read the terms and services of KDP. They have very clear and specific guidelines on what you can and cannot be using on KDP. So you must read the terms of service for all programs you're using, including but not limited to what's designing the things that you're putting into your books and where you're publishing these low content books. If you have further questions on this, go ahead and drop those down below. We want to make sure we're getting those questions answered for you. And Tony's coming back for more help on the legal side of publishing. So drop those questions for us down below. And as always, you can reach out to Tony on his social medias. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called NScene. New episodes drop every Friday in Apple Podcasts, Spotify, or wherever you listen to podcasts.
If you have questions, drop those down below, and we'll see you for upcoming episodes as we help you navigate your marketing to make this your most profitable year ever with less stress, less overwhelm, with the easiness of being able to create luxury time inside of your business so your businesses are working on your behalf while you're living your best life and still being profitable. We'll see you in the upcoming episodes.